Ladies and gentlemen, as our international webinar will be commencing shortly, I would like to remind all of our participants the housekeeping rules to ensure the smooth sail of our event. Firstly, I humbly request for all the participants to mute your microphone. This is to ensure no interference to the audio when the speaker is presenting. We also encourage you to turn on your cameras so that our speaker can see a couple of friendly faces. Should you have any questions, feel free to ask at the end of the session to the respective panelists. We encourage you to take videos or photos throughout this webinar. Don't forget to tag us at Lex Aquatica and at Ecology on social media too. We will begin in a couple of minutes. Before we start off, we would like to remark that we owe it to our children to be better stewards of the environment. Ladies and gentlemen, it is very heartwarming to be able to have you all here today. Allow me to introduce myself. My name is Laika Zamanudin, a final year law student of University Malaya, Malaysia. Our host, Lex Aquatica, is a student-led initiative aimed at disseminating information and stimulating discussions on international and domestic laws related to the marine environment. As part of Lex Aquatica, the Malaysian Millennium Oceans Discourse is one of the first events for this month. Ecology is also a wordplay on the word ecology and law. It's a sub-project under Law Society with a vision and mission to address as well as to provide a platform for students to raise their concerns on environmental issues. Ecology has been working closely with Lex Aquatica in achieving its goal for this tenure. I shall now invite the director of Lex Aquatica, Mr. Pratt Yukon, to continue with our webinar.
Thank you so much, Ika. First of all, I'd like to welcome everyone to the first of 3 Lex Aquatica events, which is the Millennium Oceans Discourse, protection of marine biodiversity through international law in the 21st century. I personally feel it's a very important topic that we're discussing today, and very happy to have Rocky, Attorney Gloria, and Pradeep here to take us through this topic and how it relates to our domestic legislation, and especially in protecting the marine environment. Before we begin our session today, I do have a few words from the Millennium Campus Network's founder, Sam Verga, which I will play for everyone. Just give me a second until it loads.
Hi, I'm Sam Vagar, him from Boston, Massachusetts in the United States. And I serve as Executive Director of Millennium Campus Network, MCN. We are a global nonprofit supporting emerging social impact leaders on university campuses worldwide. This is our 15th year here at MCN working with young leaders, now 9,000 alumni of our programs. And we're always looking for young leaders who are championing and advancing the sustainable development goals in their communities. So I wanted to just take a moment with this discourse to affirm and celebrate the work of Lex Aquatica and the team with Ecology and everybody at and in the community who is championing this important discourse at the nexus of marine biodiversity and international law. This work is so timely, and we are humbled at MCN, alongside our partner, the Remmer Family Foundation, to be able to support the work of Lex Aquatica through the Millennium Oceans Prize. You all can take great pride in knowing that the student leadership at stood out amongst hundreds of applicants all around the world. It's why we're so proud to support Lex Aquatica through the Millennium Oceans Prize, and why we're so excited for this Millennium Oceans Discourse. The world is watching. We know that your leadership matters, and we are committed to sharing outcomes of this discourse through our global newsletter, which reaches over 70,000 young leaders and universities around the world. And if there's anything else we can do to be advancing this work and this discourse and its outcomes, please reach out to us. We're here to support at MCN. And I just want to thank both the organizers, everyone involved at also the moderator and panelists. We're eager to hear about the outcomes, your insights, and we're grateful to play a small role in supporting this important conversation. So congratulations. Thank you for all you all are leading on, and looking forward to all that is ahead. Thank you.
Thank you, Sam, for kindly giving opening remarks to today's Millennium Oceans Discourse. Next, I'd just like to take everyone through today's agenda. We will first start with the presentations from both speakers, and then we will go into a moderated discussion followed by a Q&A session. I do encourage everyone to be active and ask questions. And if there are further questions, you can also reach out to us at the end. Without further ado, I would like to introduce our moderator today, Mr. Roger Joseph Guzman, or affectionately known as Rocky. Rocky is an environmental lawyer and a policy specialist with extensive background on ocean issues. He is also the Deputy Director of the Asian Research Institute for Environment Law, where he works on strengthening the rule of environment law in Southeast Asia. Now, I know it's without saying that he has a lot of background on marine issues, ranging from marine conservation, plastic pollution, to legal reform and protecting environmental rights. He was also previously the policy campaigner of Oceana in the Philippines. Without further ado, I would like to welcome Rocky. The floor is yours.
Thank you very much, Yvonne, and good morning, good afternoon, good evening to everyone across the globe who are tuned in today in this webinar. A huge welcome to you all. My name is Rocky, and yes, as Yvonne mentioned, I'm the Deputy Director of the Asian Research Institute for Environmental Law, and I'm honored to be the moderator for today's session on the Millennium Oceans Discourse webinar entitled Protection of Marine Biodiversity Through International Law in the 21st Century, which is a very important topic with so many recent developments globally and also for the region here in Southeast Asia. But first, as a backdrop on the issues that we'll be highlighting today. With the turn of the new millennium, we've been seeing that the marine environment is being threatened now more than ever. These threats include huge environmental crises such as overfishing, marine pollution, oil spills, which have really besieged our oceans, further worsening its already sorry state. This is also compounded by many emerging and new threats such as deep sea mining, the impacts of plastic pollution that we've seen in recent years. But to combat such threats, the global community has agreed on key multilateral agreements. We know the Law of the Sea Convention, or the UNCLOS, and the Convention on Biological Diversity, or the CBD. And new challenges, however, have also led to the evolution of new multilateral treaties and legal instruments, such as the one on biodiversity beyond national jurisdiction, or BBNJ, and a new potential treaty on plastics that was recently announced and committed at the 5th United Nations Environment Assembly in Nairobi a few months ago. With all these, I'm pleased to share that our speakers today will give their thoughts and expertise on addressing these threats and on the effectiveness of international law in protecting our seas. We'll also be talking about emerging issues in the marine environment and how law in general, both from the international perspective, translating the domestic sphere, has resulted or can result in saving the world's oceans. So for this session, we'll be beginning by the presentations from both speakers, followed by a discussion and a Q&A. So for the Q&A, please feel free to ask your questions through the question box below in your screens. Please be informed that this is also streamed at the Ariel and Ecology Facebook pages and YouTube pages. And I encourage everyone following us on Facebook and YouTube to please join also in the discussion and share your thoughts. Now, without further ado, I'd like to welcome our very first panelist, Attorney Gloria Estenza Ramos, or whom we fondly call Golly. Golly is the Vice President of Oceana in the Philippines and is a member of the Executive Committee of Oceana International. Oceana is the largest international advocacy organization solely protecting the world's oceans. Now, before joining Oceana in 2014, Golly was a lawyer advocate for the environment, for women and children's rights, and good governance. Along with other lawyers, she sued on behalf of the whales and dolphins, or the resident marine mammals in Tanyon Strait, a marine protected area in the Philippines, affected by explorations for offshore oil drilling. The case won through a landmark decision rendered by the Supreme Court in 2015. Golly is also a faculty member of the University of Cebu College of Law, where she served as the first director of the mandatory continuing legal education program for lawyers and represented Southeast Asia as director of the IUCN Academy of Environmental Law. Golly, thank you so much for being here, and over to you, please.
Thank you, Rocky, and congratulations to the convener of this very important platform for discussion on protection of our ocean and the need to work together and collaborate. So to the ecology and as powered, I like the word powered by Lex Aquatica program, and congratulations for winning the Millennium Oceans Prize. And I'm happy to be here. Thanks for inviting us here and share our experience. And and I will now share my screen. Okay. As to the question, wait, okay. As to the question, have we progressed in the new millennium? Definitely, I would say yes. There had been so many initiatives where stakeholders, not just state parties, are more visible and engaged in ensuring that we leave an ocean healthy for the present and future generations. So I am going to share with you what civil society sector has done in the Philippines, and sharing the lessons learned as well and next steps. And definitely, this is a platform where we would like everyone to be fully engaged in the many questions that will arise, which I hope will be raised after our presentation. So I'm with Oceana. I led Oceana since 2014 when it established its office in the Philippines. Our target really is restoring ocean abundance in the country through science-based national policies. And we are seeing reforms taking place, and that's why I'm very happy to share with you what we have encountered and what the situation is right now. So there's a need for overhauling management, improving enforcement. The Philippines is rich with very progressive legal framework for protection of constitutional rights to health, right to healthy and safe environment, and also for transparency, accountability, and protecting of habitats. But we need fully engaged civil society organizations to collaborate with government and other agencies for this to become a reality. So as I've mentioned, we have very strong legal framework. Our constitution is pro-people, pro-environment, pro-participation. And I'll share this with you. We also adopt the generally accepted principles of international law as part of the law of the land. So this has helped us a lot in the various cases filed. And of course, there is that duty, primordial duty of the state to protect the nation's marine wealth in its archipelagic waters and territorial sea and exclusive economic zone, and reserve its use and enjoyment exclusively to Filipino citizens. And there is also a reserved area for our subsistence fisher folks. It's from the coastline up to 15 kilometers offshore. These are reserved for artisanal fisher folks. So it's a great law, but more honored in the breach right now than in compliance. And then the right of the people and their organizations to effective and reasonable participation at all levels of political, social, and economic decision making is also guaranteed. So as you can see, we have very strong legal framework. And then for fisheries code, We also adapted it, and Rocky was part of it when we helped craft the implementing rules and regulations for this law, Republic Act 10654, which amended the Fisheries Code of the Philippines. In one of the amendment was to integrate in the declaration policy to ensure the rational and sustainable development, management, and conservation of our ocean, including the EEZ, and to pursue its commitment to international conventions and cooperate with other states and international bodies to conserve and manage threatened aquatic species, straddling and highly migratory fish stocks and other living marine resources. So this is unequivocal commitment and declaration of the government to comply with its obligations, not just at the international level, but also to the people at the local and national level. So we know for a fact that we are now in an alarming state of decline, not just in the Philippines, but globally. And climate change will definitely exacerbate what impacts we are feeling now, the alarming decline, the overfishing, and plastic pollution and unregulated coastal development, which if we do not do anything or just, allow it to deteriorate, then it is a dire world indeed for the future generation. Philippines particularly is important because we rank second to Indonesia and having the most number of people with high dependency on marine ecosystems, nutritional, coastal protection, and even economic, because the livelihoods of millions of Filipinos rely on healthy and vibrant ocean. And as this figure would show, the Philippines is among those who are so which is so dependent on a thriving ocean environment. And we are part of the Coral Triangle, which holds 2/3 of the world's richest reef ecosystems. And it's unfortunate that our fisher folks are considered as among the poorest of the poor, together with fisher folks, the children. So this goes to show that the policies at the national level have not really redounded to the benefit of the communities. And in terms of rights of environmental defenders, we rank second in the world, considered as the most dangerous countries for defenders and human rights campaigners. And in Asia, we rank first. So this is indeed a very challenging area for human rights advocates to be in. But there had been reforms, as I've said. So we found these issues in 2014. There is still some of these are still prevailing, and these are among the reasons why there is weak fisheries management. There was lack of collaboration, which is so important among government agencies, lack of data, arbitrary decisions not based on science, lack of accountability and transparent governance, and lack of capacity of staff. So there was one event in 2014 which paved the way for the reforms. This was when the EU slapped a yellow card warning to the country for its failure to take measures to fight illegal, unreported, unregulated fishing. So this is then Fisheries Commissioner Maria Damanakis. And right away, because the consequence would be so dire, you would not be allowed to export our fish and fish products to one of the biggest buyers. We enacted the Fisheries Code as amended. And these are strong measures indeed, if fully implemented, to bring back the health of our ocean, vessel monitoring, no restraining order for enforcement of fisheries laws, citizen suit provision, we have this, and protection from harassing lawsuits against citizens and enforcers, and of course, science-based management. So how are we doing it? How did we, when we first started, what strategies did we do? So first and foremost, we have a very strong legal framework. So the law has been our ally um, ever since. And we have to ensure science-based decision making. And of course, media is important. There are only a number of us, but with the media, and that includes social media, then the message will get across and stronger constituencies will also evolve and are evolving. And of course, dealing with the public, grassroots communities, non-government organizations, youth organizations, and direct advocacy, which means really directly um, talking with decision makers. And we also bring in the fisher folks and allies in this conversation with the decision makers. And that this formula has proved pivotal for us to be able to reach our goals. So these were our campaigns, and I just would like to highlight that when we campaign for the protection of Benham rice, which is considered by the Convention on Biological Diversity as an ecologically or biologically significant area, we use this as one of the modes of messaging that this needs to be protected. So the support from the international community was very helpful in pushing for the protection of Benham rice. So this is Benham rice. Oceana was part of the expedition. It was a government-led expedition to the area. It's now called Philippine rice. And according to the Convention on Biological Diversity, it is a relatively pristine 13 million hectare undersea plateau. It's a new part of the considers new territory of the Philippines, and it is the only known spawning area of the Pacific bluefin tuna, which is considered one of the most expensive fish. So in 2018, President Duterte signed it as a protected marine reserve, and this one in Barong is Rocky Guzman. Sorry, Rocky, your face was cropped. And so that really helped a lot in the advocacy. Okay, for stopping illegal commercial fishing, we were faced with lack of data. I mentioned this. So what we did was establish a platform with the League of Municipalities of the Philippines in the country. Coastal cities and municipalities are given the primary responsibility of protecting municipal waters, which are reserved for small-scale fisher folks. So we partnered with them. We established this platform called Karagatan Patrol or Sea Patrol, where with the use of satellite technology called VIRS, there's detection of night lights, which are apparently illegal fishing happening in our municipal waters. So because of this, we've been able to show the extent of commercial fishing, possible commercial fishing, detected through super lights in our municipal waters. We never had any idea about that. The data from government was not complete, not updated, and there was no collaboration among agencies. So now we can show, and we have data from 2018 up to the present on the extent and how this has continued. Illegal fishing has continued, though it has slightly declined, but there is still the big issue on commercial fishing. So this came from our data, on the VIRS data, and I hope some countries who would be interested would also get in touch with us, and so we can share this technology. So from 2016, we pilot tested the use of vessel monitoring because it is a new technology for many. But 2 years after, we didn't see any political will from the government to implement the rules to cover all commercial fishing vessels, which is required under the law. So we filed a lawsuit together with fisher folks. And 10 days after we filed the case, things started to move. So our campaigns now focuses on ending commercial fishing in municipal waters, use of Karagatan Patrol, protection of sardines, establishing fisheries management areas, and rebuilding fisheries through science-based management, we now have a science-based advisory group, which would make recommendations for the management body to help them come up with decisions which should help in the rebuilding of our oceans. Okay, so there are now 12 fisheries management areas in the country, and the Department of Agriculture has established this in 2019, and we started talking with the scientists all over the country in 2016, and now it is a reality. So this is paves the way for better management of our fisheries, but of course, with any reforms, um, it's also slow, but with the establishment of management boards, all have been established. Scientific advisory group, I think 11 of 12 had been established. So we're getting there. So that's why I said reforms are slowly being implemented. And for protection of protection of our very important areas, we also went into an expedition during the height of the pandemic and made sure that um, the team returns COVID-free, and we were very successful. And we discovered a very pristine area which deserves protection under our national law. So these are the members of our team who went there and were so amazed by what they saw, that some had excellent coral cover. And this is another another issue which our coastal communities face. We call this dump and fill campaign, which destroys corals, seagrass, and mangroves, cover that with land, and build shopping malls in other area and other projects, which have displaced hundreds or thousands of fisher folks and their families and have destroyed our marine ecosystem. And we're very happy that the Department of the Interior and Local Government, which supervises our local governments, has pull in the plug on this big gap between the law and the implementation, and so has required local governments to sign under oath that they have complied with all the requirements set by the environmental impact statement, by the fisheries laws, and other related laws to ensure that our ecosystems are not sacrificed in the name of the so-called development, but development for whom? So we have been very visible in working with communities in fighting these projects, and really pressuring our agencies to do its job. So this is a very powerful tool. We have adapted or launched the Citizen Scorecard. This is a consolidation of the learnings that we had in fighting this illegal coastal development projects, and this will guide our fisher folks, coastal communities, other even private sector in assessing what the procedures are and what the remedies are in the event of adoption of projects which destroy the environment. Likewise, for fighting plastic pollution, and the Philippines is considered one of the worst sources of plastic pollution, we have a very progressive law, Republic Act 9003, which was enacted in 2001, and which already required this policymaking body, the Commission, to come up with a list annually of non-environmentally acceptable products and packaging, which objective is to ban the manufacture of these items in the list. And per the definition, this should already include single-use plastics. So this is really addressing plastic pollution at the source. So imagine if this has been done since 2002, 1 year after effectivity of the law, and every year thereafter, I don't think the Philippines would have been in this unglamorous position of being considered one of the world's world's source of plastic pollution. So what we did was file the case. We also collaborated with local governments who are really being made the recipient of all of this plastics, single-use plastics, which cannot possibly be managed unless they are banned at the source. So they joined us in pressuring the commission to come up with a list. Until now, they have not done so. So what we did was send a notice to sue as required under RA 9003, and no action being done. We finally sued in October of 2021. And in December 2021, the Supreme Court issued the 2 writs directing the government to respond and how they are addressing the plastic pollution. I'm not sure if I can share this with you, but this is our refill campaign now for the soft drinks companies to increase the share of refillable bottles instead of the throwaway single-use plastic bottles, which are prevalent, because doing so would mean millions of plastic bottles diverted from our ocean. So let's have this refill again campaign, and the Philippines is among those which is considered as having a large share, but we need to do more. Okay, so all of these milestones had been reached because of close collaboration with decision makers, with our allies, with the those deeply affected coastal communities, even with the church. And of course, we always highlight the role of communications. Likewise, we did surveys to show that the decision makers how people feel about it. Number one survey in the survey that we did in 2017, the number one problem that the people saw in our ocean is really the plastic pollution. Second is climate change. Third is illegal fishing. So all of these partnerships and webinars we have done, the pandemic has not deterred us from reaching out. And because of the pandemic, largely, we were able to reach out to the fisher folks who have adapted the technology, which is a welcome use. So these are what we intend to achieve from our campaigns. And we have one ocean, and this definitely will redound to the benefit of our ocean. So thank you so much.
Fantastic. Thank you very much, Golly, as always, for that insightful, inspirational sneak peek on what Oceana does in the Philippines. And, it's very important work that you do here. I'd like to highlight one important thing that you said, that collaboration is important and civil society engagement is important. And that has been shown in the Philippine experience. And that has led to policy reform and to changes on the ground. Civil society sector contribution is huge in the Philippines. So thank you again, Golly, for that.
Thank you.
And also highlighting on the role of international law. That's very important on the CPD, and how it has led to victories on the campaigns on establishing more marine protected areas. So that's one thing that we can learn from in other campaigns across the globe also. So thank you again, Golly, for that very fantastic presentation. And please, if you have any questions, just put them in the question box below in your screens, and we'll have a good time to have a discussion later with both of our panelists. But now let me proceed to our next panelist, Mr. Pradeep Arjan Singh. So Pradeep is from the Center for the European Environmental Law at the University of Bremen. He graduated with first-class honors in Bachelor of Laws from University Malaya in 2009. He continued his studies and graduated with a Master's of Law in Global Environment and Climate Change Law at the University of Edinburgh, as well as a Master's of Law from Harvard Law School. Now, Pradeep is currently a PhD candidate at the University of Bremen and the University of Waikato, and he has published widely on issues such as the seabed mining, and most recently, he assumed the role of the Deputy Chair of the Ocean Law Specialist Group at the World Commission on Environmental Law at the IUCN. Pradeep, we're honored to have you. You have the floor, please.
Thank you very much for the introduction. Allow me to share my screen. Great, thank you very much. Good morning, good afternoon, good evening, everyone. It's a pleasure to be here with you today and to join you virtually from Germany, where it is now, I guess, 3:30 in the morning. But I'm very happy to be here and very, very proud of the initiative by Lex Aquatica and Ecology, from my alma mater, University Malaya, Faculty of Law. I'm really pleased at your efforts, and congratulations from my side as well on your success for this Millennium Ocean Discourse. I'll be speaking mainly on the protection of biodiversity in areas beyond national jurisdiction, and in particular to highlight the importance of the future BBNJ instrument, and I will be detailing this a little more during the presentation. Just to start off and to pick up from where Gloria actually left off, it's very clear at the moment that the global ocean is facing unprecedented levels of threat. No matter which corner of the world that you go to, including coastal as well as on the high seas, each corner of the ocean is facing unprecedented levels of threat. We've heard this many times, including very recently, again, repeated from the UN Secretary General just a few months ago. And when I first started, gaining interest when I was a student in University of Malaya and very concerned about ocean issues, I was actually very optimistic and said that, okay, in a few more years, we should be able to turn things around. Unfortunately, I have to, again, share this news as Gloria did, that there's still a lot of work to be done. Now, as Rocky mentioned in his introduction, when we speak about marine biodiversity and international law, the two instruments that really speak out is the UN Convention on the Law of the Sea, 1982, or UNCLOS, and then the Convention on Biological Diversity, 1992, or the CBD. Now, I think one important note to make here is that UNCLOS by itself is not strictly an environmental treaty. It provides the legal framework to take environmental action, whereas the CBD is more of an environmental treaty, but it's not exclusive to the marine environment as well. So I think that's very important to bear in mind. Another point to bear in mind is that even though the UN Convention on the Law of the Sea, UNCLOS, was adopted in 1982, it only entered into force in 1994, towards the end of 1994, whereas the CBD, adopted in 1992, came into force in 1993. So actually the CBD entered into force earlier than UNCLOS, and I think that's quite remarkable. At the bottom of the screen, that there are two charts, and the only intention to sort of put it there is to show, how complex international ocean governance is. On the left, you would see, there are many organizations, many bodies that are involved in it, including on the left where they have sort of divided it also by sectors, and you see mining, fisheries, and one on biodiversity coming under the auspices of UNEP. What is interesting is that this chart, has not incorporated the UNFCCC or the UN Framework Convention on Climate Change. And I will speak briefly on that later on, because at the moment it's been finally accepted that the UNFCCC needs to engage with the interaction between ocean and climate change. And I think that's quite important. Now on the right, instead of looking at instruments, it's actually looking at institutions and actors that are sort of involved in ocean governance, and from the core sort of indicates organizations that are with the direct mandate, and then it sort of decreases as it goes out, and you see, for example, the EU as well, which its mandate is not just for the marine environment, but for so many other things. So just again, don't pay too much attention on these graphics. It's just to give you an idea that it's complex. Now we, keep saying UNCLOS, the Convention on the Law of the Sea. What did it actually mean? It's widely regarded as the Constitution of the Ocean. It provides a legal framework on ocean governance, as well as the rights and interests of states. Now, the current status is that we have 167 member states, as well as the EU, that are parties that have ratified this convention. It designates maritime zones, and as I said, prescribed rights and obligations of all states, coastal states, including also landlocked states. Part 12 of the convention is specifically dedicated to the protection of the marine environment. And the provisions of the convention, it's legally binding on all member states, and member states have to give effect to the convention through domestic law. And I think the presentation by Gloria earlier is quite telling on how this should be done. Again, maritime jurisdictions, just in case some of you are not too familiar with it, and it's very important because I will be speaking about areas beyond national jurisdiction. So I want to be sure that we are all on the same page. There is the territorial sea that goes up to 12 nautical miles. This is essentially considered part of the sovereign territory of the coastal state. Then you have the exclusive economic zone, the water column, where states have sovereign rights over the resources that are there. So they don't actually own, or it's not within their sovereign territory, but they have exclusive rights for exploring and exploiting natural resources, living and non-living, as well as the continental shelf, the continental margin below that. And this extends up to 200 nautical miles. In some cases, the continental margin, so the seabed, can be extended pursuant to a special process with the Commission on the Limits of the Continental Shelf. And this can be extended, in some cases, even up to 350 nautical miles. But the fact that the seabed can be extended, that does not apply to the water column above it. So that would be, once the exclusive economic zone ends, would be the start of the high seas. And this is areas beyond national jurisdiction. The same for the continental margin, based from where the extension is the limits of the extension ends. That's where what is known as the international seabed or the area starts. And I will be speaking more about the high seas and the area, which collectively are referred to as areas beyond national jurisdiction. So again, ABNJ, that's the acronym that I will be using in the presentation. We refer to the high seas and the area. When we say the high seas, we're talking about the surface and the water column that lies beyond the limits of national jurisdiction. And here we have the freedom of high seas, which includes, navigation, laying of cables, fishing, and so on. Then we have the area, which is a separate regime. It's basically the international seabed and the subsoil that lie beyond the limits of national jurisdiction. And UNCLOS tells us that the area and its mineral resources are the common heritage of mankind. Just want to also highlight here that, when we say, these are areas beyond national jurisdiction, that is true, but it doesn't mean that it's beyond control. And one fact to remember here, that on the high seas, it's still the flag states that are expected to exercise jurisdiction and control over those vessels. And when it comes to the area, I will be discussing this a little later, you would need sponsoring states to sponsor mining activities. And without a sponsoring state, you cannot conduct any mining activities. So there is still the element of control. On the right, I just sort of highlighted, if you wish later on to look at the convention, you can go to part 7, which is on the high seas, and part 11, which is on the area, and you could look at those provisions further. Now, where is areas beyond national jurisdiction? I think it's quite important before we go into BBNJ and deep seabed mining. Now, on the left, you have the colors in dark blue. That's the exclusive economic zones of coastal states, and the areas in light blue, that's basically the high seas. Now, in contrast, when you look at the right, this tells us where the area is. And as I explained earlier, the area would be smaller than the high seas because of the extended continental shelf. And so this chart on the right puts down the existing as well as accepted extension claims to the continental shelf, and that is highlighted in red. And then you have those colors in beige, which tells us where the area or the international seabed is. And I think it's quite useful to even put statistics to this. You have the high seas, that's probably about 70% of the world ocean is the high seas, about slightly more than 2/3. But when it comes to the area, we're somewhere about 55% or so. And so the extension of the continental shelf has basically caused an impact on the size of the seabed that falls outside of national jurisdiction. Now, why should we care about areas beyond national jurisdiction? And I think this is very important because if you look at it from a three-dimensional perspective, it's actually the largest habitat in the world. It forms 95% of habitable space, but only 1% of the areas beyond national jurisdiction is actually protected at the moment. The areas beyond national jurisdiction, the deep ocean, plays a critical role in sustaining all forms of life, including human life, because it regulates the climate and provides a lot of other ecosystem services, including to support the marine food web. And we're just starting to learn more and more about the deep ocean. We know very little about it, but we're learning more and more. And it's very important because we need to accept that the problems of the ocean space is closely interrelated, and we need to consider these problems as a whole. And we already know this even in the convention in UNCLOS, which, as I said, was adopted in 1982. And it's quite telling that in 1982, this was already clear to us. Now at the bottom, I wanted to pay special attention to this publication from a couple of years ago, because it was one of the first few that started to indicate to us in clear terms the ecological connectivity between areas beyond national jurisdiction and coastal waters, and why this is important. And so it essentially tells us that the ocean is interconnected, and whatever that we do in areas beyond national jurisdiction will come back and affect us and affect coastal communities. So even though it happens that far away beyond 200 nautical miles, it stands to affect coastal communities. And on the right, the chart on the right, actually shows us that not only would what we do in ABNJ affect coastal communities, it would affect coastal communities that are primarily from developing countries. And I think that's something that we also need to sort of think about, because we would then, developing countries would be the ones also then, lifting the burdens of what goes on in areas beyond national jurisdiction. And since this publication, more and more research has sort of come out to further substantiate this. Now, I'm going to come very soon to BBNJ, but I first wanted to cover the concept of implementing agreements. So we have the Convention on the Law of the Sea, which, as I said, it's a legal framework for everything related to the ocean, and the Constitution of the ocean. But what has sort of happened is that implementing agreements have been used in the past to sort of fill in the blanks or to even modify the convention. And interestingly, this sort of approach has been used predominantly in relation to areas beyond national jurisdiction. So if we look at the two previous occasions where we've had implementing agreements negotiated and adoption, the first one is that was in 1994, adopted in 1994, specifically relating to the implementation of Part 11 of UNCLOS, which is on deep seabed mining. The second precedent is in 1995, which is when the implementing agreement relating to the conservation and management of straddling fish stocks and highly migratory fish stocks was adopted. So essentially this targets fish stocks that move from exclusive economic zones from one to another, as well as those that move into the high seas and come back into exclusive economic zones. And so this was a gap that UNCLOS did not cover, and it was sort of addressed through this UN fish stocks agreement. Now, what we have that is currently ongoing is negotiations to have a third implementing agreement potentially, which is the BBNJ instrument. Now we say BBNJ, but what is it? Well, the long term for it is the development of an internationally legally binding instrument under the UN Convention on the Law of the Sea on the conservation and sustainable use of marine biodiversity, marine biological diversity of areas beyond national jurisdiction. So pretty long. In short, we call it BBNJ. Now, the BBNJ instrument is negotiated under the auspices of the United Nations, and it's understood that it would come under UNCLOS as an implementing agreement. Now, at the bottom, I've sort of put this as a sort of timeline to let you know, or to at least demonstrate to you that this is not something new. It has been, in the working for a very long time. In fact, it was in 2004, I believe, when the first resolution was adopted to establish a working group to look into this matter. And the working group meetings took place between 2006 to 2015, led to a resolution by the UN General Assembly to convene a preparatory commission. This preparatory commission worked for 2 years, and then another made recommendations to the UN General Assembly, which then passed a resolution to convene what is known as an intergovernmental conference, or IGC. So we've had now, through the resolution, it was mandated for 4 meetings of the IGC. It was expected that IGC 4 will end in 2020, but because of COVID, this was not possible. IGC 4 actually took place just last month. And as I will cover in my next slide, they did not manage to complete the negotiations, and so we are now possibly looking at a 5th IGC. Now, when we say BBNJ and the negotiations, they are, it's agreed that the BBNJ agreement will be negotiated as a package comprising of 4 pillars or elements. The first is on marine genetic resources, or rather how genetic resources from marine species can be accessed, used, and their benefits shared in an equitable and transparent manner. The second pillar is on area-based management tools, or how to regulate human activities in ABNJ in and around ecologically important or vulnerable marine areas in a more integrated manner using spatial management tools. The third element or pillar is on environmental impact assessments, or in other words, how do we evaluate the impact of current and future human activities on the marine environment, and when activities are known or deemed to have an impact, how do we seize them or establish regulations on how they are to be carried out? Finally, which is an important pillar, is on capacity building and technology transfer. Or in other words, how do we ensure the ability of developing as well as geographically disadvantaged states to participate in ABNJ research, commercial use, and management? Now, some progress has been made in the last meeting, but each of these pillars, each of these components are subject to their own certain matters of contention. For example, when it comes to marine genetic resources, there are still some hard positions on both sides. Should there be a licensing or a permitting system, or do we just have a system of notification? For area-based management tools, there's no consensus yet on where do we create marine protected areas, and what would the ecological criteria for this be, and who would actually be the decision-making authority. Would the conference of the parties of this new BBNJ agreement be the ones that makes the decisions to designate marine protected areas, or can they only make recommendations and ask other management bodies to do this? Environmental impact assessments, again, a lot of contention here on, if indeed there is a duty to conduct environmental impact assessment, what is the threshold that actually triggers it? And should such environmental impact assessments be subjected to just mere notification and conduct, or should they be also subjected to approval? Finally, capacity building and technology transfer. This is a very crucial one because, some delegations during the last meeting also sort of lamented on the fact that even UNCLOS itself, since 1982, had provisions on capacity building and technology transfer, where developed states were expected to provide, capacity building and to transfer technology, but have failed to do so in 40 years. And so what exactly would capacity building under BBNJ actually mean? So these are all elements of the package that are being negotiated. Progress was made, but there are still areas of contention. So as I said, IGC4 was held last month in New York. Coming to the third bullet point, many actually said that the meeting was the most productive meeting throughout the IGC process, and made unprecedented progress in all four elements. As I mentioned, IGC4 did not conclude the negotiations, and instead, they're going to call for a fifth negotiating session that would presumably take place in August. But as I mentioned in the beginning, the mandate for the IGCs were limited to 4 sessions. And so they would have to go through the UN General Assembly to get this extension. In the meantime, in the intersessional period that we have now, the president of the Intergovernmental Conference, she's going to use this period to provide a revision of the draft treaty text, taking into account all the interventions that were made in March, and produce a new revised text to take negotiations further. Now, the Convention on Biological Diversity, so moving away from UNCLOS to CBD now, I think, as I mentioned, this is the other, main treaty that is, very relevant when we speak about biodiversity and international law. So what we had previously from 2010 to 2020 is that we had the Aichi targets under the CBD. So these were essentially 20 targets that were adopted in 2010 and expired in 2020. Unfortunately, bad news again, none of the targets were met. And so there's a lot more pressure now on what we do post 2020. And of course, because of COVID, we are now already in 2022. But the intention is to develop a global biodiversity framework, which is essentially a set of agreed global conservation goals, targets, milestones that are to be achieved by 2030, with the aim to contribute towards achieving the CBD's 2050 vision of living in harmony with nature. And so these goals and targets will be global in scope and of course, therefore applicable also to areas beyond national jurisdiction. And what's quite interesting is that, a collision of government and NGOs actually, called the High Ambition Coalition for Nature and People. So you see this at the bottom left. They've actually come together and called for this 30 by 30 target to be achieved through this global biodiversity framework, which means 30% of protected areas by 2030. And I believe there are probably somewhere near 68 or 70 countries that have joined and signed on to this High Ambition Coalition calling for this 30 by 30 target. So preparatory work is actually still ongoing, as noted in the bullet point. We're still at the first draft, and discussions actually took place last March. Unfortunately, not much progress was made, particularly relating to marine and coastal biodiversity, which is on the agenda. But the items within this marine and coastal biodiversity is actually a hotly contested area. And so the preparatory commissions were not able to complete work with respect to the marine and coastal biodiversity elements. And so this matter would then be taken up in the next COP of the CBD, so COP 15, that will happen in Kunming. But in the meantime, there would still be, an attempt to make some progress intersessionally as we wait for the COP 15, which would likely take place in August. Now, speaking about the BBNJ, I think we also need to talk about other developments that are ongoing, including political ambitions and other multilateral processes. So we have Agenda 2030 and the Sustainable Development Goals, or SDGs. We have SDG 14 specifically on life below water to conserve and sustainably use the ocean, seas, and marine resources. There's also that just kicked off last year, the UN Decade of Ocean Science for Sustainable Development, and that's going to last until 2030, coincides also with the SDGs. There's the UNFCCC Ocean and Climate Change Dialogue that's coming in June in Bonn. And so, this was what I mentioned at the beginning, that, it's already quite late, but it's actually quite timely as well, that the UNFCCC has now recognized that the need to integrate the ocean element in the climate change discourse. Also at the end of June, there's going to be the second UN Ocean Conference that will be in Lisbon, Portugal. And also, as Rocky mentioned in the beginning of his introduction, the recent UNEA decision to negotiate a global plastics treaty under the UN Environment Programme. And this also, relates nicely to Gloria's presentation earlier about the problem we have with marine litter and plastics, which of course is not only an ocean problem, but is predominantly an ocean problem. Then there's the link between the scope of BBNJ with the work of other international and regional organizations, not to mention the International Maritime Organization, the Food and Agriculture Organization and Fisheries, RFMOs, Regional Fisheries Management Organizations, Regional Seas Conventions, others, everyone else, and the International Seabed Authority, which now brings me to the last part of my presentation. What is the International Seabed Authority? And you would recall in the beginning of my presentation, I mentioned the area, the international seabed. So the International Seabed Authority basically is the organization, the international organization that has the mandate for the exploration and exploitation of mineral resources. Now, what are these minerals that is being considered to be of interest? So in general, we're talking about minerals that lay at depths greater than 200 meters. So we have polymetallic nodules, bottom left, which the average depths could be even up to 4,000 to 6,000 meters, and these are being sought after for nickel, copper, cobalt, manganese, and others, smaller quantities of metals. Then you have in the middle polymetallic sulfides located at hydrothermal vents at depths between 1,400 and 3,700 meters, also for copper, but lead, zinc, and others. And then on the very right, you have cobalt-rich crusts, which are located at seamounts at average depths of 800 to 2,400 meters, mainly for cobalt. And just to sort of also mention that, at the time the convention was, first being discussed, the Convention on the Law of the Sea, which was first being discussed in the 1970s. At that point in time, it was only sort of, known that nodules would be the minerals of interest, which sort of indicates that, even as time progressed, we're just starting to learn more and more of the deep ocean, and hydrothermal vents and the potential of polymetallic sulfides were only discovered from the 1970s onwards. And it's at back then when UNCLOS was being negotiated, we thought the deep ocean was basically a desert. It didn't serve much purpose, but now we're learning how important it is, including life at hydrothermal vents, which are unique, and at seamounts, which, is very important for marine mammals as well as fisheries, and a very important ecosystem. Now, where mining could happen, just a chart on the left to sort of show that these resources can be located within national jurisdiction, although a large portion of it, especially when it comes to nodules, are located in areas beyond national jurisdiction in the area. And so the chart on the right essentially shows us where the exploration contracts so far have been awarded by the ISA. And most of this is at the Clarion-Clipperton zone, which is on the left of the chart on the right. And then you have some on the Mid-Atlantic Ridge, some on the Southern Indian Ocean, as well as in the Western Pacific Ocean, not far away from Philippines. So the International Seabed Authority, same members as the Convention for the Law of the Sea, UNCLOS, 167 member states in the EU, recently turned 25. The exploration has been going on for about 20 years now, 31 contracts awarded, mainly for majority of them for nodules, but no exploitation activities have taken place as of yet. So negotiations for the exploitation regulations, the mining code, are currently ongoing, and some of you may have seen, in the news in June, late June last year, of this sort of invocation of a treaty provision to sort of accelerate the negotiations at the ISA by putting a 2-year deadline for the ISA to complete these regulations. Now, as negotiations are currently ongoing, in fact, the ISA just had a meeting a few weeks ago that I participated in. At the same time, calls for a moratorium on seabed mining are also growing, not only at the European Parliament or at the IUCN, but also businesses such as Google, BMW, Volvo, Samsung, and other car makers as well have been supporting a moratorium or a pause on seabed mining. And at the bottom left, a group of over 600 leading marine scientists and policy experts have also issued a statement calling for a pause on seabed mining because we do not actually fully understand the environmental implications of it and could be making a mistake by going mining without first understanding the ecosystem. So why bother? And I won't spend too much time on this slide, but the environmental issues of seabed mining, it's known to be significant. These minerals take centuries to form. Organisms actually depend on them. In the case of nodules, they're actually living on these nodules. And we know now that vents and seamounts are full of life, actually. The deep ocean at those depths, it's not used to human disturbances. And the mining methods that are being considered now are known to be destructive. And we know that, even if we sort of, allow mining to happen, we know that we can't just then, try to restore these ecosystems. So not on human timescales, it's at the moment considered to be not possible. We also don't have any idea basically on the impact that noise and light would have on the marine life as well as marine mammals. And the impacts are 3-dimensional, so it's not just going to be on the mine site, but sediments would actually be displaced, and through the lifting of all the metals, they're going to be processed on board, and then the waste would be discharged back in the ocean. We also don't know yet, we haven't really quantified the benefits of natural capital. So as I mentioned, the deep ocean and its important role in climate regulation, as well as sustaining the marine food web, and even to sort of provide future medical and pharmaceutical needs. Some of the sort of fauna from hydrothermal vents were actually used to create COVID tests. And so, we sort of know that a lot of this marine genetic resources could be very beneficial for pharmaceutical needs. So many knowledge gaps still exist, and we need to close these gaps. So final thoughts, I think it's a very important question that we need to continuously ask ourselves, what is, the relevance of convention, the UNCLOS, in the 21st century in the context of marine biodiversity. As I said in the beginning, we are facing unprecedented levels of threat from human activities. What about questions such as ocean justice, the rights of future generations, and the concerns of developing countries? So I think it's quite obvious that there is an urgent need, that we need overarching objectives and oversight in ABNJ in areas beyond national jurisdiction. In theory, the BBNJ agreement could play this role, but I want to note that there is this sort of understanding in the negotiations that the BBNJ agreement should not undermine other existing arrangements that already exist in areas beyond national jurisdiction. So even though the BBNJ agreement has a very important function, and we all do want to ensure that it is ambitious, this is great, but in return, what could happen is that this could actually mean lesser universal acceptance. Could also mean that during the negotiations there will be more compromise that's being made, including concessions on certain items. Another point to note is that adoption by itself does not necessarily equate to entry into force. How binding and voluntary would the provisions be? And entry into force is one thing, implementation is another thing. We can have a very good treaty on paper. How will we implement it? And then how will we ensure compliance? And in the case of non-compliance, how will we ensure enforcement? But that, having said all that, the political pressure for this treaty to be ambitious is very high, and the world is watching right now. So all eyes at the moment are on the UN Ocean Decade, the UN Ocean Conference, the 5th Intergovernmental Session Conference of the BBNJ negotiations, COP15 of the CBD, and the post negotiations on the post-2020 Global Biodiversity Framework, forthcoming negotiations at UNEA for a global plastics treaty, and finally, the International Seabed Authority. So with that, thank you very much.
Great. Thank you very much, Pradeep. It's always a pleasure listening to you on all things law of the sea and also BBNJ. So it was our pleasure to have you here. I'd like to note that I've seen that chart that you've shown in the first few slides on the complexities of legal instruments, and it always astounds me on how convoluted it is. As one colleague says, it looks like a horrendogram on how many instruments are overlapping over each other. So that's just crazy. But thank you for the presentation on the BBNJ. I know there are a lot of threats and challenges there, especially in the face of deep seabed mining and how this can also affect coastal communities, as you've mentioned. And we have these instruments, potential instruments that could protect us through environmental impact assessments, through area-based management tools. So all these legal tools that will provide us safeguards against these threats on our oceans. So thank you, Pradeep, for that presentation. And at this point, we are now at the open forum, the moderated discussion and the Q&A. So we have here Attorney Golly and Pradeep. Let me just, there you go. And we will be opening the floor for any questions. We have a number of questions already here in the Q&A box below. Let me just start with Attorney Golly. There is, I think you've mentioned this, I've touched on this briefly on the Philippine rice example, but I'd like to know more on how international laws actually influence the formulation of marine environmental law in respective countries. This also stems from one of the questions from Hannah Lim on the sufficiency of the existing instruments at the national level within national jurisdictions. So how can international complement this, and is national jurisdictional laws sufficient for the protection of the environment? Attorney Golly.
Yes, thank you, Rocky, and for these questions. Actually, international environmental law, for example, has really helped the government craft the necessary national laws as proof that there's commitment to comply with the undertaking. And so we have in the Philippines, for example, I mentioned Republic Act 9003. This is the Ecological Solid Waste Management Act. And this was enacted together with the Clean Air Act, which was earlier enacted, as compliance by the Philippines of its undertaking under the UNFCCC, United Nations Framework Convention on Climate Change. So that is one direct impact of being a signatory, but it's in the implementation, which is really the issue. That's why I always challenge our citizens and advocates to push hard for these laws to become reality, because these are empty laws and remain empty if not asserted. We cannot forever blame government for not implementing the law. We have to ask ourselves, what have I done to make sure that this mandate, my constitutional rights to health, to healthy environment, are really protected? So that's the key there. And also, if I may mention, because you have filed several cases, and you've mentioned Rocky, the resident marine mammals case, where I together with my co-steward Liza Osorio, filed in behalf of the whales and dolphins as who consider the area as their habitat or migratory pathway. When we crafted our pleadings, there were so many international treaties that Philippines was part of, and that really helped us a lot. In fact, we raised the issue of sustainable development because uh, we readily signed. We were part of so many conventions, participated in the framing of this. But it's really how these are formulated and policy actions made that proves the crucial issue. And this is where we have to be involved. So for law students who are here, it's not enough to know the law, but to know how these are being applied, or if not applied, then ask why. You have the right to ask why. But in essence, this is the way that things should be done. So we have to stop being detached, or just be satisfied in asking questions, because the pressures are just so great already. This is a survival issue we're facing, so we have to do more as citizens, as stakeholders. So yes, to answer that question, international conventions principles have been pivotal in influencing decision makers, but it doesn't stop there. We have to be more engaged.
Yeah, thank you, Golly. And yeah, Pradeep also mentioned a lot of emerging environmental treaties and conventions. It will cover everything, but at the practical level, at the national level, it's important for us to all be involved, right? You mentioned like we all have the duty to protect our marine wealth, and it's up to all of us to give life, to give spirit to that provision of the law, right? So we need more we need more people actually implementing what the law says. Now, there's also a question here. I think I'll direct it first to Pradeep, then also Golly can join in later. Can you share some progressive principles in customary international law, specifically for the marine environment, that has developed in recent years? Maybe Pradeep, you have some thoughts on that.
Yeah, I mean to some extent, there are success stories in the areas where I'm sort of practicing as well, here in Germany. I think what is quite important is this the Aarhus Convention, for example, basically on access to information, public participation in decision making, as well as access to justice. So these sort of provisions, I think it's sort of up and coming, is being more accepted as norms of good governance, transparency, and things like that. So I think that the looking at how different jurisdictions have sort of progressed in this front, it's getting more and more difficult to sort of prevent citizens from questioning whether or not things have been done. And I think, as Gloria just said moments ago, that's what we need to do. We need to start questioning our governments, and one way to get that all started is to ensure access to information. Because if you don't have access to information, then there's very little you can do. And once you have access to information, then you need to have avenues to participate in decision-making processes as stakeholders. And if that is not working out, then you need to have recourse to the judiciary. And so I think that customary international law is sort of evolving also in this direction as well. That the right to a healthy environment is a human right, and so that is something that we can it becomes actionable. On other fronts as well. I mean, I think some success. You could point to the International Whaling Commission, for example, because we do have a convention on whaling that is still active from 1946, allowing whaling to occur. But what has happened in recent years is that the political body, the Whaling Commission, effectively has implemented a moratorium on whaling. And so, whale stocks have recovered. And I think that's also, from the international sort of side, a success story, even though the convention itself was created for whaling, but right now it's sort of being used for the reverse as a conservation organization. So that's quite interesting.
Right. And those are very important points, Pradeep. You mentioned the Aarhus Convention in Europe. Primarily, it's my dream to have this kind of similar convention in Asia and the Pacific, because these principles are really important: access to information, access to publicly participate meaningfully in decision-making for environmental matters, and effective remedy. Now, these are really important key pillars of environmental governance that we want to see on the ground happen here in Southeast Asia. Maybe other principles, Goli, you might want to share?
Yes, I mentioned that part of the sources of law is the principles of international law, and we have been good in embedding those in our constitution. For example, full disclosure, that's a policy of information, and then right to access justice, of course, that's also there. And our Supreme Court has even adopted the only known rules of procedure for environmental cases, where when you file environmental cases, you don't even pay filing fee. So that's a great incentive. It's really opening our courts when it comes to environmental issues that prevail. And then Fisheries Code also embedded this precautionary principle. We have that. I know some jurisdictions don't have that, but we have embedded that in our national laws and even in the rules of procedure for environmental cases. So in a way, Philippines is so privileged to have all of these principles as actionable, but we need to bring this to the level of the citizens, because many are not aware that these are can be used by them in redressing their grievances against government. So as Pradeep said, there's a lot more that needs to be done, but it's there already. The law is our ally. I guess we have to thank our progressive lawmakers and constitutional makers for having all of this. So it's in our hands already. So let's do something about it.
Right. Yeah. We're also always proud to share that we have these progressive laws, like even procedural laws. The rules of procedure for environmental cases in the Philippines is one of the more revolutionary, so to speak, laws, which encapsulates everything, like all these principles of environmental law, which is a very good model for other jurisdictions as well. And so that's really a huge win for all of us in terms of environmental law. And a question here on ABNJ, Pradeep, is there's a query here. So what is your take on the suggestion on the protecting all of the area beyond national jurisdiction? So it's a very tricky question. Is it even possible from an international legal framework that we have right now?
Well, I would say, theoretically speaking, yes. Practically speaking, no, because there's going to be a lot of opposition to this. But I think, a lot of scholars and scientists have sort of, started to point out that, if we do, theoretically, if we do protect ABNJ very, cautiously and very closely, then we would solve a lot of the problems of the ocean. So they have started to sort of provide methodologically, they've sort of, sort of assessed it and say that, okay, if we can protect ABNJ, then our coastal waters can sustain, such levels of anthropogenic pressures that we are putting on it now. Even though that's not such a good idea, it doesn't apply, for example, to fishing, of course. But if we can sort of protect it, theoretically speaking, that would solve quite a lot of problems. So the scientists are saying that. But of course, practically speaking, we know that this is difficult. You might say that, okay, we can sort of close the ABNJ to certain activities, for example, fisheries, if you're able to do that. But what does that mean with respect to other activities like mining, for example? Are you also going to close that that area for mining activities? And I've been attending meetings of the International Seabed Authority for some years now, and I don't see that happening. I see states are pushing in that direction. Now with the negotiation of the mining code, they want to go forward. So, if indeed, the ISA is going to sort of take a different approach now and say that, okay, we are going to agree to a moratorium, we are going to ban seabed mining, there can be repercussions, and there can be some states that have mining interests that are going to react to this and say that, hey, this is not the purpose that you were created for. And again, to come back to the whaling example, as I mentioned, earlier on, we had this convention to enable whaling activities to happen, but right now it doesn't allow it to happen. And what happened recently was Japan left the whaling convention because they disagreed with how things are being done. So again, if you try to do something like this, I'm not sure you could have repercussions, and then you could have states saying that, okay, then we are going to leave the convention and do as we please, and you don't want that as well. So it's a tough question. I believe, if everyone is on the same page and everyone says, oh yes, we do need to, close off the high seas and the international seabed. If everyone says yes, then there's no problem at all. It's a good thing, they will do it. But if people refuse, and if these are powerful states, then we have a big problem.
Right. Well, did you want to add something to that, or?
There's also an evolving trend from international NGOs working together, coalition, as a form of pressure or collaboration with states on, because there is really a need for all stakeholders to work together. So 30 by 30 is also a great initiative. And if it can be embedded at the national level, then progress forward to have that push, considering, and there's really a need for people to understand why we need to do it. I think that's a compelling reason for more to join in. That's also one of the reasons, perhaps. So there's the reason we have this ASEAN regional cooperation, but at the local national level, we don't feel it because we are not engaged, and not many have really taken the cudgels for support for ASEAN. From the perspective of civil society sector. But now, looking at the 30 by 30 movement, for example, who knows? So we start small, and I know we will get there, but we need more. And perhaps our law students will be a great
Yeah,
part of that. I'm
indeed.
always hopeful.
Yes, you always need that. Excellent points. And even for, aside from 30 by 30, we have a lot of networks also, particularly looking at deep seabed. We have the Deep Seabed Conservation Coalition also looking at that. So these difficult questions, we might have some answers, and we just need a little push from different sectors, society, from all over the world, right? To answer, to have a solution to these difficult questions, as you said, Pradeep. Now, there's one question on, they really wanted to know more about the Tanyon Strait case. You've mentioned this, Golly, the resident marine mammals case, which is a very interesting landmark decision in the Philippines. So we're represented whales and dolphins. So could you please just share us some of your lessons from this and how maybe other jurisdictions from across the region, across the world can learn from what you've done in this case?
Thank you. It was not just me, but it was really a citizens movement because of the big threat. This is the offshore drilling for oil happening in a protected seascape, the biggest protected seascape, this Tanyan Strait protected seascape, um, but with no management body. So you wonder, how was this approved? There was no management body. And so, you know what? It started, well, the fisher folks were the first to be alarmed, of course, because this impacted their livelihood. But scientists were the ones saying this spells disaster. So I remember it was Dr. Lem Aragones who is with the Philippine Association for Marine Scientists. They passed a resolution opposing offshore drilling for oil. At that time, I was more into solid waste management. And I remember I told Lisa Osorio, my co-steward, oh, you can handle that. You're with the coastal conservation, CCEF, which was on coastal education. But then when I heard from Dr. Aragones and saying that, my goodness, Cebu hosts the most number of whales and dolphins, something, struck within me that, we should do something to protect this. So we called for a meeting among those who already opposed, and there was an agreement to really widen the information drive. It was important for stakeholders to know what is at stake, what will happen. So there was a curriculum. I mean, amazing. We didn't have money. We didn't never depend on money, but we contributed our skills, our knowledge, and there was a lot of grassroots mobilization in Cebu. Then we went to Negros because this covers not just the province of Cebu, but also the provinces of Negros Oriental and Negros Occidental. And Tanyan Strait Citizens Movement was formed. And I'm just so proud to be part of that. Like, I could never imagine such a citizens movement happening. So we tried all means. But when we saw that the president, the governor of Cebu were determined to go through with it, and in fact, they started offshore drilling already. And the whales and dolphins disappeared. And what's so sad, the fisher folks who under the constitution have preferential access to their fishing grounds were not allowed to fish. And many of their children had to give up schooling because they didn't have money anymore for food and everything. So that's why we thought of coming up with a lawsuit. Definitely, two lawsuits, two cases. One filed by the fisher folks because they were directly impacted, and the other on the whales, in behalf of whales and dolphins, because this is the migratory pathway of 14 out of 27 species of whales and dolphins in the Philippines. So Attorney Ben Cabrino was the counsel for the whales and dolphins, and Dante Ramos was the counsel for the fisher folks. So Lisa and I helped in the research and all. There were some dramas, but I don't have to spell it out. But the thing was, it pushed through. And what was key in this fight was the law. We all have the law. The environmental impact statement was system process was not followed. What was done was just an initial environmental examination, which is a no-no for an ecologically critical area, such as the protected seascape, and an ecologically critical project, which is offshore drilling. So, and there were many requirements which were not complied with by the government. So we put everything there. And it was actually Tony Oposa who gave us the inspiration. Why don't you sue in behalf of the whales and dolphins? So he's a major part of this drama, of this saga. When we filed the case, we were really prepared. We prepared hard. We gave up our Christmas holidays just so, or our vacations just so we're able to find it, to file it. Media also played a pivotal role. Like media was there from the very beginning. They saw it evolving to become a citizens movement. So when we filed the case, we faced media, and they really also made a big difference. So 6 months after we filed the case, the offshore drilling company withdrew. Okay, but the case was still pending in the Supreme Court. This was in the withdrew May of 2008. But the Department of Energy said we will rebid. So we said we will not withdraw the case. We will not withdraw the case because there's that threat. So we did. But it, there were no more takers anymore in that. Offshore drilling was exterminated, was stopped. But a day before Earth Day of 2015, so the decision came. And I couldn't believe it was 7 years after we filed the case. And what happened was 2010, the Supreme Court crafted the rules procedure for environmental cases. And what they did was, you see the ownership by the Supreme Court. They put in the provisions of the rules of procedure for environmental cases in that decision. It was never in our pleadings, but they were the ones who put that in to consider if we had standing to sue. And of course, the Supreme Court reiterated the Oposa versus Factoran case, which we can sue on behalf of children and those yet unborn, and added that it is not just a right, but a duty of every citizen to protect the environment. So as stewards, we had that duty. So perfect. And we would have thought that, this would provide the ground rules for government to go into ecologically destructive projects, but the fight still continues.
That is a very seminal case for environmental law, not just in the Philippines. And it's really an example of how you can use creative means in environmental law as opposed to other fields of the law, right? So you've done a very good job on using this and on using creative legal means to file cases and actually do something on the ground, right? It led to a lot of it led to no more offshore drilling that's happening in a marine protected area at that.
Yeah, and I just want to add that those who are into this don't even know that our rules are so strict, like municipal waters, that's for fisher folks. But why is the Department of Energy encouraging investors for offshore drilling with this reserve area? So we were approached by those provided the service contracts. They wanted to withdraw. They were not informed by government that they cannot. So this is where really collaboration is important. We don't, they have their business interest, but they have to know the legal framework, and because it means a lot of money down the drain. If they don't.
Thank you for leading the way for all of these. This leads to a floodgates of litigation, hopefully in the future, because we have so many tools that we can use. Now, we can go back just to international level, because there is a query here, Pradeep, on the original conception of the area as a common heritage of mankind. Could you just please share us how it's evolved throughout the years and how the relationship has changed, especially as to developing countries on their access and benefit sharing of the resources in the area? Pradeep?
Sure. It's definitely something very close to heart as well. And I was actually just speaking about this a few hours before this, and in the sort of work that we've done recently. I can't show you, but it's sort of a publication also to sort of track how the common heritage of mankind was originally envisaged and how we're actually sort of putting it into practice today. So I'm sure some of you would know that one of the main reasons why we have UNCLOS today is not only because of the other problems that we were facing on the ocean, but it was also one of the main impetus for it was, this mineral resources on the international seabed. And we wanted to come up with a regime that sort of ensures that, these resources will not be exploited by, on a first come, first serve, might is right basis. And so at that point in time, it was the 1960s, and more countries started to gain independence. So, it was, sort of post colonization era when more and more countries started to get independent, and sort of wanted to also ensure that, they would, eventually be able to have access to this area. And so the developing countries back then, their view was basically, let's set this as the one common area, mineral resources for all of us, common heritage. And their proposal back then was not to allow individual states to go and mine, but rather, why not we have one mining entity to conduct these activities for everyone. So all states come together and support one mining entity. Now, developed states didn't like that idea, and that's why they already had, to some extent, the technology, or they thought they had the technology to do it, and they didn't want to agree to this. And so they came up with a compromise that, okay, states can do mining, but we also have this mining entity under the ISA. The problem is, with capacity building, transfer of technology, this mining entity has still not yet come into operation. It's called the enterprise, and developed states have continued to block it. So at the moment, when we sort of come to 2022 right now, and discussions that are going on at the ISA, it's actually quite good to see developing countries such as African countries, making it very clear, very firm that they want to see this mining entity for the ISA be established, because they see it as the most effective way, for example, for them to take advantage of this common heritage of mankind rule principle. Another aspect to look at it is the benefit sharing element, which was mentioned in the question. I think that's a very good one. A lot of developing countries might not have the interest to do seabed mining. They may think it's very risky, but at the same time, they're also looking to sort of receive certain revenues or income from seabed mining through the ISA. And those negotiations are going on right now at the ISA, including to set a price, how much contractors should pay the ISA. And there are countries taking different views. Some say we should set the rates low because we need to attract contractors and investment to come in, whereas people like me say we need to set the rates very high because we don't know the environmental consequences and the losses that we're going to suffer. So that's being negotiated now at the ISA, and there are differing views, as well as the methods in which whatever income that is received, how it's going to be distributed, and if developing countries should get a bigger share of the cake. That is also still under negotiations, and we'll wait to see.
Right. Just a lot of challenges, but I'm happy to learn that a lot of developing countries are in the table, are part of the conversation, this access and benefit sharing issues, right? And there are recent developments such as these guidelines that are really addressing all these difficult questions. No? Yep, thank you, Pradeep. And I'd just like to pose like one last question to the both of you, since there's really a question here is if the system of international legal instruments that we have and institutions and the law itself, is it effective in addressing all the issues hounding our oceans? And what are the areas really of marine international law or international law focusing on the marine environment that need more attention that you can foresee in the future, in the next few years, perhaps? Like, any thoughts for that? Emerging issues that you can see?
There are so many.
Maybe just a few. Prioritization.
Overwhelming. One is really, well, the plastic pollution. It's really something to be concerned about. We have to do something about it at the local and national level. And of course, the the industrial fishing cannot go on unabated. That's why we need to have the technology, and citizen engagement to make sure. And it's so important to collaborate. Like Philippines, for example, has these port state measures, but it's not being implemented. So, and of course, we need to have more marine protected areas, because this is going to be to provide the resilient ecosystems that we so badly need. We have climate change in our backyard already, and so many more. But these are among the key issues that need to be addressed. And it's not as if we are lacking in instruments. There are already. It's more a more active engagement and collaboration among stakeholders.
Right, right. Agree. Pradeep, any thoughts?
Yeah, I can only agree. Yeah, it's collaboration, involvement of stakeholders, and a few other themes that are particularly concerning, as well as knowledge, ocean knowledge, ocean data. These elements, we need more of this, and we need this to be shared immediately. And there's just a lot of proprietary elements to this sort of data that are being held back by those very few people who are able to collect it, and not share this. And this is also the same the case that comes back with seabed minerals as well, and the common heritage, because a lot of this geological data or resource related data for the international seabed, these are considered proprietary data. So we actually don't know the value of these resources. Those that collect it can actually trade it and sell it, all at the same time, when we are the owners as humankind of these resources, and yet we don't know this sort of data. Even though at the moment now there is a push at least for environmental data to be disclosed, but we just need a lot more of this knowledge and data. And very closely linked to that, and I think Gloria also mentioned this in her presentation, is this science policy interface. We need to be able to get science into our policy, into our laws, and things like that. So we need science to help us develop criteria, indicators, and things like that. And that's where we also need to push a lot. And this closely relates to capacity development, also in developing countries. And then that's another very important theme that
Right.
we need to sort of address. Yeah.
Yeah, excellent points, Pradeep and Gauri. Yeah, and as we close this panel session, I just want to get a few lines from you, parting words for our participants, for our students, for future lawyers here in the webinar. Just please share any of your final thoughts before we finally close this program. Who'd like to go first?
Seniority.
Go
Yeah, I think it's from Jane Goodall. We're never too small to make a big difference. So we should put that in mind and believe in our dreams. Everything starts there, and we have to be determined to make a big difference in our own circle. So what I congratulate Ecology for this fantastic platform, and I look at it as the first of a series. Maybe we can do more work together, and of course with Ariel. Thanks so much.
Thank you very much, Gauri and Pradeep.
Yeah, sure. I mean, just to say that, yeah, it is indeed already late. We very much needed to address all these problems a long time ago, but it's still not too late, and it's never too late. We need to do it right now. Start taking concrete action, concrete measures. And what we need to do as the younger generation is to push our governments. Not allow for inaction to happen, and whenever we see any opportunity, we need to apply the pressure, because otherwise nothing is going to happen. The problem is just going to keep exacerbating. But we need to take advantage of the movement now about climate change, for example. 5 years ago we would not have imagined the sort of traction that we have now, and the youth sort of really putting pressure on governments to act. And we are seeing, some very, encouraging, changes in quite a few governments. And I think, eventually, in the next few years, we can, do the same for the ocean and bring it in the forefront of things. And that's my parting message. Yeah.
All right, thank you, Pradeep. Great words, great parting words, and a shout out to the youth and the students here in this webinar. And as we close this program, I'd like to thank the panel, Pradeep and Golly, who has shown us how urgent, hard-pressed we are in crafting solutions to save the world's oceans. We've also seen on how they've used law, both at the international level and domestic level, and to use this as a potent force to address the problems facing our oceans today. So thank you very much, Pradeep. Thank you very much, Golly. On behalf of the organizing committee, I'd like to thank everyone who went here today for their time, and for everyone, to our panelists and our organizers for their time and expertise in actually organizing this event and making this happen. Again, this has been Rocky Guzman from Ariel. It was truly a pleasure moderating this webinar today, and I hope you found this session to be an insightful one. So before we end, I'd like to hand over the floor to the ecology organizers for a quick photo op, I think. So may I hand over to Melvin, or to direct us to our photo op. And please, could you please open your videos? Right, just let us know if you should smile.
All right, I'll just get a quick picture. Okay, 1, 2, 3. Okay, one more. 1, 2, 3. That's it.
Okay. Thank you, Rocky,
thank you very much.
everyone.
Thank you,
very much,
Rocky, Ariel.
And
Hold on,
Bye-bye.
everyone. Hold on, everyone.
Just
Ika
a
has a
note.
few words. Ika?
Okay.
Yeah, go, Johan. I'll hand it over to you. Just a note that the recording of this session will be available on our YouTube pages, both Ariel and Ecology, so do look out for that. And then I'll hand over to Johan for the closing for this session. Go ahead.
Okay, go ahead, Ika.
All right, so on behalf of the Ecology Lex Aquatica, I would like to thank our attendees, panelists, Tony Gloria and Pradeep, and the moderator, Mr. Rocky, for sharing your expertise with us today. A huge shout out also goes out to the MCN and Remmer Foundation, in particular Noha, who is here today, and Ariel, Mr. Matthew, Mr. Rocky, and Ms. Colin for believing in us and supporting the event virtually. As for the topic today, we believe that international law has and will continue to have a role to play in the protection of the marine environment. Thankfully, it doesn't end here, and with the millennium, it doesn't end here with the Millennium Ocean Discourse. So we hope all attendees will continue to discuss and further the cause of protecting our marine environment at all levels. Since we have an international crowd, I would like to draw your attention to the Millennium Ocean Student Forum, which aims to gather and publish evidence of convention implementation related to the marine environment from all around the world. We hope to present this paper in the inaugural issue of Lex Aquatica proceedings and in an online forum in June. So participants may choose to write, share research and analysis topic related to the marine environment. So the deadline of this submission will be extended to the Wednesday of 4th of May 2022, so do participate. And again, thank you to everyone for your time, and please keep updated on Ariel and also ecology events by following our respective social media pages. The first one is at ariel.asia. The second one is at Ecology UM, and you may want to follow at Lex Aquatica. So take care and stay safe until next time.
Bye.
Bye. Thanks.
Thank you,
Thank you,
everyone.
everyone. Thanks, Rocky. Thanks, Gloria. Bye, everyone.
Thank you.